Welcome to the Music Law Beat. I'm Bill Huckberg, and I'm really excited. I'm joined today by Tim Kappel. He just won an appeal in a copyright case in the Fifth Circuit that has knocked the music business on its ear and could knock it on its rear if it rolls into other circuits. We're going to talk about what it is and whether people should be panicking or rejoicing or neither of those. It's going to be a real interesting conversation here. Also joining me is my law partner, Rami Yani, who's an IP and entertainment lawyer at Raines, and he's an adjunct professor at USC Law School, University of Southern California Law School. Tim is also an adjunct professor at Loyola Law School, by the way, in New Orleans. So without much further ado, from the Fifth Circuit, which comprises the Mississippi Delta, the birthplace of the blues, New Orleans, Louisiana, the birthplace of jazz, and Texas, the home of such great country music, Western swing, Austin outlaw music, and you name it, a real musical district, the Fifth is. I bring you Tim Kappel. Welcome, Tim. How are you?
Thank you, Bill. I'm good. Thanks for having me.
Great to have you. And also, we have the Grammys coming up, and I understand you might be in town, and that's going to be real interesting for you because a lot of people involved in the Grammys, including creative people and business people, are really interested in this case.
Yeah, I'm fortunate enough to serve as the president of the Memphis chapter of the Recording Academy, which encompasses Louisiana, Mississippi, Western Tennessee, Arkansas, and Missouri. And so I'm in my first year as president of that chapter and have been a part of the Recording Academy a long time, and I'm looking forward to being out in LA next week.
Fantastic, Tim. So I'm going to sort of give my take on what happened with this case, what this case is about, and you can correct me if I'm wrong, or Rami as well, because I know you're so into it. I mean, actually, the ruling just came down like 9 days ago. And so basically what I understand the case is that you have a song, or you represent Cyril Vetter, who owns, he had a co-writer, but he owns 100% because he acquired the co-writer from the estate of the co-writer of a song. The song is called Double Shot of My Baby's Love. And let's just take a look at that song for a second. Unfortunately, we were going to play it, but we think it's going to get taken down, even though it's fair use. It's going to get taken down by YouTube. But in the show notes, you can actually look at it. So I'm going to just try to show you what we're talking about here and go
Bill,
over
I know the guy that owns the rights to that song, right?
Okay.
We could get you some clearance,
I'm sure we could, but they'll
kidding.
take it down anyway.
Yeah.
And so for a week or so, we'll have, or more, we won't have people being able to watch this. So that's
No
the
worries.
trouble with it. But I appreciate that. So anyway, I'm going to basically share this screen over here for a second and show you guys, hopefully. Yeah, okay, so can you see this? Yeah, so it's the Swingin' Medallions, Double Shot of Love, and here they are. Why don't they have Swingin' Medallions on? That I don't know, but they're great. A great song that actually Bruce Springsteen called it. What did he call it, Tim?
Something like the greatest frat rock song of all time.
Okay, and here's a video of him performing it with the Swingin' Medallions here back in 2009. Been covered by George Thorogood and a few other people. It's not a huge song, okay? So it's got a respectable million views, few million views here, but it's not a huge song. But this is so not a lot of money at stake here, but a very principled lawsuit for sure. And so right now, can you see the actual opinion here by the judge, you guys?
Yep.
Okay, and so this was Judge Carl Stewart, a 3-judge panel. And so what the case was about, it's really a case about the Copyright Act renewal and termination rights. What does that mean? That means that no matter how bad the contract was that you signed, if you're a songwriter or you're an artist of any kind, or you're a musician, you're a writer of romance fiction, whatever, you name it, no matter how bad the contract was, you can, after a certain number of years, you can get it back, you can terminate that horrible contract. And that's been great news, and so it's, you call your publisher and you say, hey, that period of time has come and I'm going to terminate. And then they say, yeah, but only in the United States. And you're like, what? No, only in the United States. The law only applies in the United States. So you can go ahead and terminate in the United States, but we're going to own it for the rest of the world. That's been the way that it has worked for going all the way back, I don't know what, Tim, to 1909 Act, or what was it, however far back it goes. But it's, or under the 1976 Act. Okay, so what happens then is that the publisher or whoever you're talking to says, well, that's great, it's just for the US, so we'll own the rest of the world, thank you very much. And what does that do? It means you're going to renegotiate. So they're usually going to keep, the company is going to keep the song, but it's going to be a better deal. That's kind of how it is operated, but you have opened the door in the Fifth Circuit to it being a worldwide thing, not just the US. So that means that you could, a creator could come back after that number of years is up and say, I'm terminating for the world. If your Fifth Circuit opinion win here rolls over to the other districts or goes up to the Supreme Court, we're still in the period when we don't know whether they're going to file an appeal or not. Such a fresh opinion. But if it holds, it's going to be, and it holds currently in the Fifth Circuit. It is the law in the Fifth Circuit. If it holds, you're saying, well, I don't need to deal with you anymore. I'm just going to take it for the world. Thank you very much. So that's basically the long and the short of it. I know I'm missing a lot. We can go, and we will go very much into the weeds here, but we're also going to keep a legal eagle eye view and try to keep it on a higher level. But just to get a bit into the weeds here, the important years to keep in mind are 1967 and 1988. That is because the Copyright Act of 1976, which was effective January 1, 1978, has Section 304C and Section 203A. Okay, so they say that you get this termination right, and if it's a work that was first created, or it was first copyrighted or published before 1978, then you have a 56-year. After 56 years, you get back. You can get back the U.S. rights if you file a notice, and then you need to record it as well. And you have to give them two years notice. You have a 5-year window. I know I'm getting in the weeds here, folks, but trust me, it's 1967. If you didn't exercise those rights and you have a song before 1967, you missed it. Okay, if it's after 1967, and that was a pretty nice year, 1967, right? You had, you had Jimi Hendrix, Are You Experienced? You had Bathing It. You had Surrealistic Pillow from the Jefferson Airplane, Grateful Dead's first album. A lot of big albums in 1967. Then and after, and a lot of Aretha Franklin and James Brown. Great stuff in 67. And 1988. If you entered into an agreement after 1978, then it would be Section 203A, and that means that you have a 35-year window. You also have to give 2 years notice, so that means effectively you have 38, if I'm not mistaken, 39 years. And that means 1988 is the big year. So anything from 1988 and forward, you have a right to terminate. So what was in 1988? You have Michael Jackson, Man in the Mirror, Springsteen's Ton of Love, Prince, Whitney Houston, Guns N' Roses, Sweet Child of Mine, a lot of stuff in 1988. If you are talking about before 1988, you blew it, you missed it. It has to be a termination notice for anything from 1978 to 1988. If you snooze, then you lose.
Your work deserves more than attention. It deserves protection. Rains is trusted by artists, producers, and creatives across the industry. With offices in Los Angeles, New York, Chicago, and beyond, we bring sharp legal thinking to litigation, business, real estate, and private client matters, protecting tomorrow and delivering today. We've got you. Reigns.
So we're going to talk about now what this opinion is so earth-shattering, because what it says is it's not just the U.S. rights, folks, it's the worldwide rights. And so, Tim, I'm going to stop talking here and let you talk a little bit about where do we're going to actually take a look at the agreement itself. Maybe is that how you want to get into it, or is there anything you'd like to mention as an overall point about this?
Yeah, well, I mean, I think that the important things, maybe just the important points in time, is that Cyril and Don Smith, his co-writer, assigned the rights over in 1963 to a publisher called Windsong, and then Don Smith died in 1972. And so there was an original under the 1909 Copyright Act. There was two terms of copyright protection, two 28-year terms. So an initial 28-year term, and then the possibility of an additional 28-year term if you undertook certain filings. In the original contract with Windsong, both Cyril and Don had promised the renewal right to Windsong as well. And so in 1994, when the renewal copyright was obtained, Cyril had to transfer his renewal copyright to Windsong, which is what gave rise to the termination right that was exercised in 2021. But Don Smith, because he was not alive, his heirs took that renewal copyright free and clear. And so Vedder later acquired Don Smith's interest, which is why this case is such a unicorn. There's never been a case that has adjudicated both the geographical scope of renewal rights under the 1909 Act and termination rights under the 1976 Act. So that's what makes this case such a such a unique thing. And so we were very proud and very happy to bring this on Cyril's behalf.
And I guess it was you who actually laid out the case. I didn't actually get to the facts of it, but we're going to. I want to point out too that there's no legal advice being given on this that anyone should rely on. We are giving opinions about this, but you should consult with an attorney if you have an issue about that. The other thing you just mentioned, Tim, renewal rights, and I was talking about termination rights. They're bound together in a way because they're in the same statute, 304 of the Copyright Act. But they're different, and it's complicated. And don't try this at home, folks. You need not only an attorney, but an attorney who understands this stuff to explain your rights. So why don't we go through? Can you see this page here where the Judge Stewart, outlines the three issues here?
Yeah.
Okay, so the first, so he's talking about what Resnik, who was the buyer here of this song, is saying. At first, he asserts that Vedder's notice of termination does not affect foreign rights based on the plain language. Like, hey, it's just plain language right there in the statute, easy peasy, right? We'll get into that. Second, he contends that the district court's interpretation of the statute contradicts case law on the statutory termination of foreign rights. So we'll get into a discussion about some of the interesting cases involving music, like I hope we can talk, Rami, about the Fami v. Jay-Z case. We can talk about Corcovado case, which involves the great bossa nova of Antonio Carlos Jobim, and some other cases that come up. And third, he maintains that the district court's holding conflicts with U.S. treaty obligations under the Berne Convention and Universal Copyright Convention. And Rami, I'd like maybe to have you talk here about, some people are saying that, like, look, the Berne, and it's in some of the papers here, the Berne Convention isn't a copyright act, okay? There's no copyright law created by the Berne Convention. How does the Berne Convention figure into this, Rami? Or can you talk to us a bit about the Berne Convention here?
Sure. So the Berne Convention, which has been around for over 100 years, I believe, it's got 168 contracting states, and it's a global copyright convention that establishes the parameters for respecting copyrights of copyright owners, creators of works of authorship in these various countries that are parties to the convention. And one of the principles of the convention is the principle of national treatment, which treats work that originate in contracting states. It gives them the same treatment in one of the other contracting states as that contracting states gives to its own nationals, meaning that even if your country gives you a certain scope of rights, in enforcing your rights in our country, we will not give you broader rights than we give to our own nationals. And that's where this becomes a little tricky, because we have here a right that I think is unique to U.S. Copyright Act. I understand that there are some foreign acts that place certain restrictions on grants of copyright ownership, but I'm not aware of any foreign territories that
Okay.
allow a grantor of copyright to simply terminate
So, I
right
mean,
previously granted.
sorry
Yeah,
to interrupt you, Rami, but I
yeah,
think we're getting a little ahead of ourselves, which is great, and what you're saying is amazing. I think we should get to that again, and as that's the third one here in blue here, and some people are listening to this and not watching it, so that's most of what we're saying. I think will come across. But anyway, that's we are jumping a little ahead, and I think it's okay too. And I think I'm just going to jump a little ahead here too, and just put this out there to you on this issue, which is the third issue here in blue for those watching. Aren't there are other laws that we're talking about national treatment, which is basically saying you are in country A, there's country A and country B. Okay, so country A is America and country B is Britain, let's say. Okay. And if you're in country A, if you're from country B, or it's a copyright from country B and you're in country A, you're going to be subject to country A's laws, copyright laws. Is that idea? But on the other hand, the way that I think this case comes down is that it's, people are saying, well, that it can't be. It's like with copyright, every single country has its own copyright law, and we have to look to that. But it's actually been bifurcated. In other words, there are two issues with copyright. One is about who owns it. The other is about what happens if somebody infringes it or does something else to it. Okay, and if someone and I think what this case is saying, and you correct me if I'm wrong, Tim, is that the ownership you determine on where that baby was born. Okay, where was that copyright born? If it was born in Britain, then you're going to apply on who owns it. You're going to apply British law, and they don't, like you said, Rami, they don't have a termination right there. If it's born in the U.S., you're going to apply the U.S. law. Okay, so that's on where was it born. Or ownership. But on infringement, if somebody infringes it, or let's say somebody is ruining your work, moral rights or something like that, and you need to enforce against it, then you go to the law of the place where you're at. Am I right on that, Tim? Is that sort of the theory of this case?
Yeah, that's basically been our theory of the case, is that questions of ownership should be answered in accordance with the country with the most substantial relationship to the work, which is usually the country of origin. And then questions of infringement would be answered by the law of the country where the infringement occurs. But it's the Fifth Circuit opinion is interesting in that regard because although we have pressed that theory, ultimately the court didn't look at this as a choice of laws case. It actually just approached it from a straight statutory interpretation case, which is an interesting aspect, sort of casting aside all of the arguments that were around the ITAR task case that we relied on so heavily, and said, no, we're just going to look at this as a matter of straight statutory interpretation. So it was an interesting. I wouldn't say it was a rejection of our overall view of that. I think the court said we don't need to go there because we're just going to look at the statute and the language of the statute.
ITAR tests say just what I said, which is that ownership is based on the country where the thing was born, and infringement in those kinds of cases, you look to the country where the infringement happened. Rami, would you agree with that?
I think that's what ITAR TAS, it's one of the holdings in ITAR TAS, but if I may, I just want to poke a little hole in that reasoning. And, I know that case made a distinction between rights in the case of infringement versus ownership. But I think there's an argument to be made here that this is a distinction without a difference. Um, a case of infringement is
Oh,
going to revolve around whether or not someone owns rights to a particular copyrighted work. Um, it is about ownership. To say, well, if it's an ownership question, we're going to go to the country of origin where the work was created. If it's an infringement question, we're going to go to the country where the
yeah,
work was
but
infringed. I'm not sure that that's
no, but Rami, you can chew gum and walk at the same time, right? You can have a case where you're going to look to local law to determine whether it was an infringement and what happens, and you can look at the other country's law to determine who owns it. Is that right, Tim?
Well, I mean, Rami's not. This is something of a philosophical debate. I mean, I wouldn't say that it's necessarily settled. I mean, many circuits follow ITAR-TAS and that approach, but there are still those. I think Nimmer's view on it is that you don't have to follow the country of origin approach that was done in ITAR-TAS. I mean, it's certainly our position, and it makes perfect sense to me. But I'm not going to take the position that there's no other reasonable interpretation of how copyright law should work. But as it stands, at least in the Second Circuit under ITAR-TAS and in the courts that have followed the approach in ITAR-TAS, initial ownership questions, the predicate or the antecedent, as they would say, the antecedent question of copyright ownership is decided using the laws of the country of origin, and then the infringement question is handled under, lex loci delicti to get, Latin on it. But that's kind of the way that courts have approached it. And then you have the next question, which was hotly debated in the context of ITAR-TAS in this case, was, well, does that apply to transfers of ownership? Should we determine questions around transfers of ownership, or in our case, a reversion or a termination of that transfer? Should we look to foreign law to determine who owns those rights, or domestic law?
But
So,
isn't that an ownership question?
well, that's certainly our position, Bill.
yeah, I think it
Yeah.
is. I think
Yeah, so if that's
transfers
an
of ownership.
ownership, sorry, Rami, go ahead.
The ownership, renewal, transfer, I think all fall under the umbrella of ownership. And I think that what I'm saying is, I'm not so sure that infringement also does not fall under the ownership umbrella. So that's all I'm saying. I'm still not entirely persuaded by that distinction between ownership versus a claim of infringement, which at its core is going to be a claim that someone does not have ownership.
I mean, you could
So
have a
that's all I'm
claim,
saying.
theoretically, Rami, could you not have a claim that about who owns something, like a declaratory relief action without an infringement action?
Yes, you could.
Just purely that?
Certainly.
I mean, you could.
Certainly.
And then
Uh,
one last point, and we're going to get back to these
yeah.
three things that the judge said, but one last point is that there are lots of laws, US laws, that are looked at in other countries and actually abided by. I mean, there's OFAC, the sanctions that other countries don't have, but they follow those. There's export controls, regulations. There's antitrust law can apply to foreign conduct that produces substantial intended effects on U.S. commerce, even when the agreements or practices occur entirely abroad, and that they don't have laws like ours. So it's not a completely new thing to say that. And Foreign Corrupt Practices Act, I think it's the same thing. It's like that countries will use, we'll look to U.S. law. It's not like this is the first time or something like that. It's not that unusual.
Well, I think there's an important note there, though, Bill, is that in which the instances in which you're pointing out are instances in which a U.S. court will apply domestic law to foreign conduct, right? So it's never that, you have foreign courts applying U.S. law. I won't say never, but that's not the principle of extraterritoriality and the exceptions to extraterritoriality. that is where the U.S. Congress decides that its laws should reach foreign conduct or foreign individuals engaged in foreign conduct. And those examples that you just pointed out in the antitrust case, Foreign Corrupt Practices Act, et cetera, that is where, they've made a deliberate exception to the general principle of territoriality.
Okay. And would this not be also if, an exception to say that ownership issues under Copyright Act are not going to be subject to national treatment?
Well, I don't bind it up. I don't, think that it's necessarily a national treatment question. But what we have always taken the position is that, there are two ways that you can overcome the presumption of territoriality, or it's actually, the presumption against extraterritoriality. And that is one is where Congress has explicitly stated, or, very clearly stated that this statute is intended to reach outside of the United States borders. But the other are in instances that you had, like in the Kurtzang case, where the statute is intended to be just geographically neutral. And our position in this case was that, like in Kurtzang, the termination provisions and the renewal provisions under the 1909 Act and the termination provisions under the 1976 Act were intended to be applied without regard to geography. And so we don't have to, split the world up into all these different pieces when when a U.S. court is determining who the owner of this particular intellectual property asset is.
And you're queuing us right up for that first question there that we will get to, right? And, the issue of whether there's one copyright for the world in terms of ownership, or it's like multiple copyrights everywhere. Before we get to that, I do want to do one more diversion, if you guys are up for it, and talk about the McCartney case. Is that something that we could do for a second here? Paul
Sure.
McCartney. So Paul McCartney, some people, and I think this case is an interesting one to compare to your case. So Paul McCartney, are you guys looking at this? This was his termination. This is what a termination notice looks like, y'all. This is Paul McCartney's termination notice that he sent to Sony ATV, and he just have a few of his songs here. He with an effective date of 2019, registration date over here. Pretty cool, right? This is Paul McCartney, and here's the complaint. And Paul McCartney, by the way, is God, right? You don't want to mess with Paul McCartney, right? Paul McCartney is, and I don't think Sony did want to, so they actually disputed it with him, and we're going to talk about that. There was a dispute over whether these are British songs, right? And whether those should be subject to, whether he can claim U.S. termination rights under that is right on point. And I think there was in the complaint, which is right here, there's some discussion about how they didn't want to get into litigation necessarily with Paul McCartney because he's God. You don't want to get in a fight with him. Anyway, he actually had these songs and he wanted to get them back from Sony ATV, and so he filed these claims. And Marty Bandier is mentioned in the complaint. It's a really interesting complaint. We'll put it in the show notes. But it didn't last very long. The complaint was filed, and then there was 6 months later a confidential settlement, and we don't really know what happened, except we can look and see how these songs, like that one that you saw on that wasn't one of the ones, but those songs, here's one of the ones that was mentioned. It won't be long, that was on that notice. And you look over here and you see who the publishers are. Well, MPL Communications is McCartney, okay? And Sony I'm not sure whether they're splitting that geographically or whether that's Lennon's half and that's McCartney's half. It's not clear. But one thing that is crystal clear is that he got his publishing back. So that was a settlement. Now, that doesn't have any precedential effect on anybody, but it's interesting to note. And it's interesting to also note that Sony made the argument that you can't use sorry, God, sorry, Paul McCartney, but you can't use U.S. termination rights for your to get your songs back. And they pointed to Duran Duran. There was a case by Duran Duran, and there were some problems with that case. It was brought in the UK, but in any event, they said, well, we'll look at the Duran case, but we're not going to give you back your copyrights. And how does that relate to your case? And it's almost the reverse, where you have someone from company B, from country B, Britain, coming to country A, America, and saying, I want to. It's sort of like Corcovado, that Corcovado case, which is Bossa Nova case from Brazil, saying, hey, we want to use American law. We don't have a connection to America really, but we want to use that law to terminate in the U.S. And in Corcovado, they said okay. And here in in this McCartney case, what happened? Tim, can you talk to that? I mean, what seems to have happened is that they said, no, you're not, we're not going to apply U.S. law, termination law here, to a foreign, to a copyright that was born in country B, Britain. We're not going to apply it here.
Yeah. Well, I mean, look, I think from our perspective, it casts some doubt on the, not going to impugn anybody's, motives, but, when the NMPA files a brief saying this is going to be disastrous for foreign writers, trying to exercise their termination rights in the United States, I think you have to kind of read that in the context of the fact that, one of the principal members of the National Music Publishers Association, it was fighting with Paul McCartney over this very issue. They've had a change of heart and are willing to recognize the termination rights of foreign authors in the United States. I'm not so sure, but the way that it is, I think you're right. I think there are some parallels to be drawn from Corcovado. Corcovado was around renewal rights and not termination rights. Obviously, the Paul McCartney case was around termination rights, but they're so linked, right? Renewal rights have been around in the Copyright Act since 1790, since the first act. And the purpose of renewal rights has always been to give the author, the author's heirs, that second bite at the apple. And the reason that termination rights exist is because the two-term copyright protection system was done away with in the 1976 Act in favor of a unitary term of protection. And so all throughout the 1960s, they were arguing, or at least the first half of the 1960s, the parties were arguing about how to give authors that second bite at the apple. And what they ultimately came up with was these termination rights. But that was not the only proposal on the table. There was at one point there was considered automatic reversions. Of course, we have a very complicated system of terminations these days, but that was sort of the compromise that ended up getting struck. But it does raise questions about how the Vedder opinion and how the principles that are expressed in the Vedder opinion apply to foreign authors. Do foreign authors still have the right to terminate transfers in the United States, or at least acquire the rights to exploit their foreign copyrights in the United States post-Vedder? I think that those cases are going to have to be litigated. We have always said that we think that there's a path to do that. Even taking our position, which is that you should look to the country in general, you should look to the country of origin to determine these ownership issues. If you look at Corcovado didn't turn on the notion that there are 181 different copyrights in the world in a given song. What Corcovado says is that renewal rights and the right for authors to obtain a second bite of the apple is a vital policy of the United States. We're not going to apply Brazilian law in this instance. And frankly, that's completely within a U.S. court's ability to do so. Just as a French court could completely ignore the principles outlined in the Vedder decision, U.S. courts don't have to decide things the way that a Brazilian court would decide things, and they don't have to decide it the way that a UK court would decide things. So I think that there's a path forward, be it through national treatment obligations, which I'm not so sure apply, or simply because the failure to give foreign authors the right to exploit to exercise termination rights within the United States would yield, a violation of a fundamental policy. Again, the problem there is you go back to Duran Duran. What does that mean for them in their home country, right? Because sure, you get the right to terminate, the assignment as far as the United States is concerned, but then they get sued in their home country, saying that this is a breach of contract because you promised us that we were going to have perpetual rights or rights throughout the term of copyright protection. And that's what Duran Duran said, is that, yeah, you can be held liable for breach of contract. And frankly, Bill, there's simply that's not the role of U.S. termination rights or U.S. renewal rights to come and save the day for foreign writers who don't have termination rights in the United or in their home countries. The job of those foreign writers is to lobby their own legislatures to say these are a fundamental right. We should have these rights
Yeah.
as authors. It's fair. And so I think that, when we get into talking about what this means for foreign authors, I never want us to lose sight of that why isn't it that these other countries are providing their authors with termination rights like we are? And that should be the question.
Absolutely. I mean, it's like the U.S. is really the only country in the world that has these laws. I mean, nowhere else has it. And so if you make the argument that this law was the basis for this law, I mean, the basis for all copyright law is to engender a more robust exchange and creation of creative and scientific material. I mean, mostly creative. It's to have a better flow of creativity in the society, right? And these laws were put in place to give an incentive to creative people to create music by giving them the possibility, no matter how crappy the deal was that you signed, you're going to get a second bite at the apple later through these laws. No other country in the world has this. So if you are making the argument that this is, that I don't know, that the U.S., that this is better for writers because I mean, the U.S., sorry, I'm losing a little bit of my train of thought here. It's complicated stuff, I got to say, but the U.S. is the only one, and so you're going to say, well, gee, France and Germany don't have it, but they're still creating lots of stuff. There's lots of great art coming out of Japan. They don't have it. You could make that argument, right? Maybe you come back and say, yeah, but the U.S. has the best stuff. And that's partly because of laws like this. I don't know. I'm just sort of like, help me out here, Rami,
Yeah, no,
please.
let me just chime in here because and clearly, Tim, you have tremendous depth in this because you've been in the weeds in this for several years now. But the Duran Duran case, from my reading, is consistent with the Fifth Circuit's outcome here, which is we're going to apply the rules of the home country. And the rules of the home country in that case for British writers do not allow for a termination right, and you cannot get the benefit of the termination rights that are available to U.S. authors under the U.S. Copyright Act, which is essentially the mirror of what happened in the Fifth Circuit in the Vedder case. But I think the core of this really is, and I keep coming back to the Berne Convention. Are we talking about, and are we asserting here that the rights granted by the U.S. Copyright Act or under the U.S. Copyright Act are international copyrights, and any grant or reversion or termination is a termination of an international right? Or is this a U.S. right? Is it a U.S. copyright that is being recognized by the various foreign country members of the Berne Convention? That's really at the core here. If they are being recognized are they being recognized as a copyright, but governed under the laws of those countries versus, no, this is a foreign copyright I'm sorry, this is a U.S. copyright that has to be treated under U.S. law. And I am concerned, even with the ruling in the Fifth Circuit here, how this is going to be enforced. are foreign courts now going to allow the termination of rights
I
granted
mean,
to?
that's another question. I mean, Rami, but on the question about whether, I think your question was, people are saying, well, the Berne Convention is not a copyright act. There's not just one copyright law under the Berne Convention. Of course not. The Berne Convention is not a copyright act, right? But it's harmonizing a lot of countries that have their own copyright acts. But again, the
Well, I think
idea.
Rami's right in the in regards to the fundamental, like the philosophical question, which played pretty heavily, I think, even though it didn't get a lot of play in the decision itself. I think the fundamental, how you treat a copyright, do you treat a copyright as a singular property asset that is recognized pursuant to treaty obligations, or do you treat it as a multiplicity of copyrights so that there is the other side has consistently argued that the multiplicity theory, that there's a French copyright in double shot, that there's a German copyright in double shot, that there's a Japanese copyright. Why? Because those are our treaty partners. Our position has always been that, that's fine theoretically. We have a different theory, which is that that copyright is a singular property right asset, the ownership and essential nature of which you determine using the country of origin, and then is respected by our friends and our treaty partners. And we were able to cite some language. I mean, look, in fairness to both sides, you know, there's no solid law, no decision that I've ever read has said, oh, there's a multiplicity of copyrights. No decision I've ever read until Vetter said that there's a single copyright interest. And even Vetter hedges a bit, even Judge Stewart hedges a bit in Vetter to say, look, this makes more sense to me. I don't think he says, definitively that there's no other argument, but
Mm.
his position and the court's position in Vetter was, as the parties have argued it, the notion that there's a single copyright interest that's respected by treaty partners makes more sense to me than it does the alternative, which is that there are 181 different copyrights in double shot.
No, and I
And I
think
just want to,
go ahead.
I just
Sorry.
want to correct myself because I think when I mentioned recognizing, I think I misspoke and referred to recognizing the copyright as each copyright being treated as a domestic copyright in each country. I meant recognizing the single global interest or single international copyright, which is what was asserted by Vetter in this case, as opposed to having what you just said, Tim. Each country basically has its own. The copyright in a song or work of authorship is a separate right in each country under the laws of that country. So I just wanted to correct myself on that. And sorry, Bill, you were about to say
No,
something.
I was just going to say, there are, even the scholars are taking two positions. I mean, you had Nimmer quoted here in the opinion. I think if you're looking at it right now, saying that
Well, I mean, the scholars have got,
arguably,
right.
okay, arguably, and for the most part, okay. So in other words, it's not. He's saying there may be another view on this, and also even Patry, who kind of did a rant, if you will, about the district court claim on yours, saying that the judge didn't know essentially copyright law, Judge Shelley Dick, and even he had in the chapter before the one where he's ranting and saying that there's, this is ridiculous. He says, there's a possibility that there's two sides on this argument.
Well, not only that, I mean, and
I'll
look,
put that in the show materials, and you have it in your brief too.
yeah, I mean, listen, let me first say that none of this has ever been to despair, like our positions, none of it has to ever been disparage Patry or Nimmer or any of the other, scholars at all. I think that what has been, look, we have not been the ones unwilling to acknowledge any room for disagreement on this. Our position was laughed out of many rooms,
Okay.
before we brought this case in the district court. And, there was very derisive tone that was adopted towards this position. And if I can quibble with Patry, it's that I found his his update in after the district court ruling in Vetter to just be way too caustic, way too dismissive
Oh, I mean, he's like
of a very
the,
smart
yeah,
person.
he is
Um,
very, he's a
you know,
brilliant guy, but he's sort of like the Bill Maher of jurisprudence. I mean, the way
yeah,
he,
I think
you know what I'm
I
saying?
think
I
that's
mean,
kind of a
here
great,
he is, like right here.
yeah,
The
yeah,
court's
yeah.
lack of understanding of international law is also evident in this passage.
Yeah, I mean, you don't say that about a federal district. He doesn't know Shelley Dick. Shelley Dick is whip smart. She's the chief judge of that court. She was, appointed by Obama, and she has more credentials than just about
No, and
anybody.
and this quote that he uses, I mean, he says that she's saying that the Berne Convention, it creates one copyright, and that's not what she says right here.
Well, no, that's not. And by the way, Patrick 25 years ago was saying the exact opposite of what he's saying right now.
No, if you look at the chapter, as you pointed out in footnote 25 or one of your footnotes in your wonderful brief, very readable brief that you wrote,
Well,
very
thank you.
long, like 90 something pages, but really, really readable and great. And so 20 here in the previous chapter that he didn't update, he says, well, there's two different views on it. The answer to that question may depend upon one's view of copyright territoriality. He's pretty mellow here, the very chapter before. So I don't think the scholars are just united in a front against this. They're
Well, he
saying
said
that,
that the single copy the multiplicity of copyrights theory was hard to defend on policy grounds, and I think a journal paper that he wrote in the early 2000s, where he said that it's proper to say that that a copyright vests in
yeah.
one country and then is
No, I
recognized by
mean,
multiple. So, I mean, he was at war. I don't know what's prompted his change of heart, but I mean, his own writing is at war with itself on this issue.
yeah,
So I just think it should to be toned down a little bit. I like this Bill Patrick, this Patry I like, where it says that it depends on one's view of copyright territoriality, because I think that's an absolutely true statement. Going and calling a federal judge a dummy is not, befitting of somebody who
no,
has
I
this
mean, and he
much
says,
knowledge.
I was a reporter, I did this, I did that. But, he's brilliant. We can't argue. We're not
Sure.
disparaging him. He is absolutely brilliant. He's devoted his life, I guess, to this. And Bill
So,
Maher is pretty brilliant too, although I don't watch him anymore.
uh, so
So I
can I
don't want
ask
to
you a question?
disparage either of them.
So can I ask a question? And this is a question for you, Tim. Um, did you take the position on behalf of your client that the statute is silent on extraterritoriality and therefore there should be a presumption of extraterritorial application of the U.S. Copyright Act?
The position was, well, so um, the position was that, like in Kurtzing, that the statute was intended to apply without regards to geography. So yeah, it's silent, right? But that's because it's the presumption of against extraterritorial application can be overcome, like I said, in two ways. One, because the statute was intended, like the first sale statute, right? I mean, Kurtzing was around the first sale
Correct.
statute in the Copyright Act, and what the Supreme Court said is that that was not intended to be geographically limited. In the Kurtzing case, Justice Breyer gave four examples, in addition to the first sale doctrine, in which the phrase "under this title" was used in the Copyright Act. One of them was Section 106 of the Copyright Act, which is about ownership. And he said, owner of copyright under this title has no geographic limitation. And so our position was, Rami, that when we talk about what Cyril's ownership interest is, again, that's dicta in Kurtzing, but it's pretty darn strong dicta when it comes from the Supreme Court, that ownership shouldn't be viewed with a geographic limitation. Just like if I inherit a pen, or I inherit an item from intestacy laws in Louisiana, when I go to Honduras with that item, the ownership issues don't necessarily change, right? I'm the owner in Louisiana because of the laws of Louisiana. And so that's kind of how we approached it,
Okay.
was that you should view this as an ownership issue.
Okay. So
I get that. I just, I keep coming back to the language in Section 304 it affects only those rights covered by the
Right.
grant
Sure.
that
So we're
arise under
gonna
this title, and in no way affects rights arising under any other federal, state, or foreign laws.
That's right.
And
Yeah.
I think you're interpreting that to say this does not address territoriality or foreign copyright laws. I
let's
think
get
that was,
right to that and look at this
Yeah. I mean,
language.
that's the hardest part of this case. Yeah.
Here's the language right here for those people who are watching, and for those who are listening. Rami, you just stated it, I think, right? And
yeah.
how can you go ahead, Rami?
Yeah, so I mean, looking at that, termination of grant affects only those rights covered by the grant that arise under this title, no way affects rights under any federal, state, foreign laws. So the question is, are the grants granted under this title? I know that you just talked a minute ago about Kirstang and the reference to the definition of under this title. Is that a grant of US rights and does not affect rights arising under federal, state, or foreign laws?
Can I put my
And this
two
goes
cents?
back to the
Yeah.
Paris Convention, sorry, to the Berne Convention.
So
Rights
can I put my
arising under
two?
foreign laws. Is this a
Yeah.
single, unitary, global copyright, or are these individual, I think you said 181, Tim, if I'm not mistaken, individual copyrights governed by the laws of those countries? And I'd like to discuss, Bill, I don't know where we are in timing, but I'd like to discuss for a minute another practical concern I have here. I mentioned earlier the practical concern of whether and how foreign courts would enforce the ruling in the Vetter case. Are courts going to recognize the Fifth Circuit's ruling? And if so, to what extent are they willing to enforce it in various foreign jurisdictions? But the other is the reverse, which is in the case that we talked about offline, is Fahmy versus Jay-Z. That's a 2018 Ninth Circuit case that involved the enforcement of Egyptian moral rights in a 1950s song. It was actually a 1950s hit song in the Middle East that was sampled for a Jay-Z song, Big Pimpin'. And the heirs of the composer challenged the use of that song in Big Pimpin'. And if you have seen the video, the music video, you might understand why the heirs challenged the use of the song, even though contractually the rights were properly granted to Jay-Z's
I mean,
record company.
that was moral rights. You've asked about
Yeah,
three questions, and they're all great questions.
yeah,
And
moral rights. That's
one
correct.
as to enforcement. I mean, why wouldn't they enforce it? I mean, if it's the law, if it's the law, I mean, I guess they could not. But I
Well,
mean, if it's the
are they
law, it's the
bound?
law. If we have like a Supreme Court case or other circuits, I don't see why they wouldn't. And the second thing on the Fahmy versus Jay-Z, that's essentially a moral rights question,
Right.
and that's a right that we don't have in this country, but they have it
Correct.
in many other countries. That's
Right.
an enforcement action. That's like an infringement action. Would you agree, Tim? I mean, that's where you would look to the local, I think you would look to the local law to see, in this case, it would be the US where they brought the action to see if there, and they had no moral rights law here.
That's how I would
Except,
square it. I mean, that's how, Rami, to your concern, that's how I square it, is that you're looking at the difference between a question of determining ownership of an asset versus enforcement of that asset. And under, national treatment principles, we're not required to afford foreign copyright holders any greater rights than U.S. authors are afforded. And because we only, and that, look, let's be honest, we do have limited form of moral rights in the United States. We had to adopt some moral rights in the United States in order to join the convention, and that's under 106A of the
yeah,
Act.
that's under the
And so,
Visual Artists' Rights Act. That's
yeah,
correct.
I mean, and so, just because Vera doesn't apply to music, but that's not to say, so when we look at 106A and the rights that are granted under Vera, it becomes clear to me that that's an enforcement question. And Vera rights are treated as an enforcement question. And so then you go say, well, are there moral rights in music? No, there's not. It's only in certain, aspects of visual art. And so I think
Understood.
you square that in that, at least that's how conceptually I would square it.
And then we come back to the issue we discussed probably 20 minutes ago or half hour ago, which is there a material difference between enforcement or infringement action versus a claim of ownership? And
Mm.
we can say, yeah, well, moral rights is an enforcement action, based on their desire to enforce rights that they do have in their home country, in this case, Egypt. Um, is there a material difference between an enforcement action and an action saying, I own this and you don't own it?
I mean, I
That's
think
where I'm still struggling.
they bleed into each other, but I do think they're distinct. Would you agree, Tim? I mean, ownership issue different than infringement or other enforcement issue. And you can, as I said, chew gum and walk at the same time. You can have a case where you look to local law for one thing and foreign law for another thing. Am I right, Tim?
I view them, I mean, that's the way I view it. But again, I mean, I'm not going to take the position that there's no other. I mean, same thing
Okay.
I said a while ago, which is that, yeah, that's absolutely the way I view it. I think it's the right way to view it. But,
Okay.
reasonable minds can
Let's,
disagree on a lot of this stuff.
yeah, and I think even Patri should agree with that. Uh, but if we look here at this language here, I think you see it, right? Like when they say, and in no way affects rights arising, and we, by the way, we have as much time as we want here, guys, but, and in no way affects rights arising under any other federal, state, or foreign laws. What do you guys think they were referring to? And they do talk about reports from the legislative history and stuff, but
Yeah.
it's not that clear because they're contradictory. What, like, when I think of a state law, I'm thinking they mean like before, for instance, sound recordings in this country were not federally protected under copyright. You had to have common law state copyright laws. And that's what I thought, maybe that's what they're referring to with the state law, one example, foreign laws.
Well, I think this language would apply if you want to use a case that we cited a few minutes ago, the Duran Duran case, right? The
Yeah,
rights to the songs in the Duran Duran case were rights arising under foreign laws. It was a UK composers.
yeah, right. So
And
arising
so
under, and the
this
court
would
gets
not
into, yeah,
this would
court
not
gets
apply
into.
to those. The rights there arose under UK law for those UK composers. So the outcome in Duran Duran is consistent with that language on its face. But as Tim,
And
I
by
think,
the way,
acknowledged, that language could be interpreted
yeah,
to say that
I mean,
the rights granted here don't
it means
necessarily
arising
apply.
under means like born in. If your copyright was arising under U.S. copyright, if your copyright was born in the United States, that's how I take it, and I think that's how this judge takes it. But the Duran case, one other thing I want to ask: how is that different than McCartney? I mean, isn't McCartney the same kind of reasoning that if Duran, the court said we're going to look to local law in terms of what the ownership is? Isn't McCartney the same thing?
The difference is that under Section 304, the termination is triggered by the date on which the copyright was secured, not the transfer itself.
Right.
When McCartney was those copyright, and at the time McCartney and the Beatles were creating those works, in order to obtain copyright protection, they had to either one, file for registration in the Copyright Office, or two, publish with notice. And so they obtained a copyright registration in the United States, and you saw that in their termination notice. You saw the PA, da 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 da, right, and the numbers after that. That
Here they
indicates
are right here.
there you
There
go.
they are.
Right. So the registration number. So what they did is they obtained copyright protection in the United States under the 1909 Act by registering the work in the United States Copyright Office. And so, because it is because the termination is governed not necessarily by the data transfer, which would, I think, implicate the choice of laws provisions and all of those things. The distinction here, and arguably it's a distinction without a difference, but you could draw a distinction given the fact that this was a termination under 304C, and my understanding is that the Duran, well, it would have had to be. The Duran case would have been under 203. So I've never taken the position that those termination provisions operate separately. I mean, they are triggered in different ways. They have different timelines, but the effect of them should be the exact same, and they both share that exception, the language that Rami was pointing out, that arise under this title language and doesn't affect rights arising under other federal, state, or foreign laws. Both 203 and 304 share that language. So I don't think that they should be interpreted differently. But if you want to be hyper technical about how they're different, it would be that McCartney's was under 304.
Okay, but what federal, state, or foreign laws do you think they're referring to in this statute?
I mean, so our view is that there is a difference or that there's a potential difference between what the drafter of this language meant and what Congress thought that they were doing. And that has to do with the winding path that the 1976 Act took to passage. It arguably, if you look at the supplementary report that was issued in 1965 by the then Register of Copyrights, what he says is that this language is intended to, essentially, I suppose, is intended to prevent what Vetter and accomplished in this case. I'm not 100% sold on that, but I think that that's a fair argument to make, that that's what the supplemental report was intended to say. And so arguably the person who drafted this language intended it to mean what Resnik and the NMPA and others say it means. However, the debate on this issue stopped in the mid-60s completely. And the Supreme Court has recognized that the legislative history, and when we do statutory interpretation, we're not interested in looking at what the Register of Copyrights thought this language meant. What we need to determine is, what did Congress intend by this language? And so when they're voting on this issue 10, 11 years later, the Register of Copyrights then comes into Congress and testifies and describes the effect of termination rights in very different terms. Says that it gives authors the absolute right to call the deal to a halt. That's what she said. So I'm a legislator. I'm in 1975, and I'm voting on what this means. And the Register of Copyrights has just told me that termination rights means that an author can call the deal to a halt. Well, when I'm looking at that language,
Is that quoted somewhere here? Am I looking at that down here? Like,
it was in a 28J letter that we filed
okay,
after
but it's not in the
briefing.
ruling. So go on.
No. It's not in the principle. It's not in the ruling.
Okay,
it was in oral argument. We brought it up in oral argument.
But keep going. Yeah.
Yeah, and so our view is that what Congress meant by this, right? That's what we should be searching for. What did Congress think that this language meant? And our position is that when you talk about other, the word other is important, right? Our view is that the copyright in double shot arose in the United States, right? It originated in the United States. The word arise means to originate in the court's opinion. So it arose in the United States by meeting the requirements of the Copyright Act. So then you say, all right, if that copyright is, the singular property interest, and Rami, I want to push back a little bit on the terminology that you use, which is a global copyright. That's not what we view it as. We view it as a U.S. asset, not a global copyright, but a United States copyright that is then respected by our friends throughout the world. So I know that's often, and I know you didn't mean this, but oftentimes people are very dismissive by saying, "Oh, Vetter just think there's a global copyright." I mean, there's not one copyright in the world. There's not a global copy. And yeah, no, we agree with that wholeheartedly. There is no global copyright. What there is a copyright that is respected throughout the world. So then you have to jump to this other language. What does it mean? A couple of things. One, you have to remember that this is an exception to a broader right. Okay, the broader right says nothing about geography. Just says they have an absolute, an inalienable right to terminate under the statute. And these are a list. This is one of the exceptions to that right. So when we look at exceptions, we've historically in statutory interpretation, we look at exceptions in a narrow way. We don't take the most expansive view possible. And that's the problem with the Siegel opinion. The Siegel opinion says, well, if Congress really wanted to vest this, they would have said so, right? So they essentially they say the exception, should be viewed broadly, and the right should be viewed narrowly. And I think that that's just wrong. So if we start there and we say we're going to take a narrow interpretation about what this exception to the right means, and then you say this word other, uh, people skip over that too because they say it doesn't affect foreign
Any
laws.
other right here, any
Yeah.
other federal,
So
state, or
federal,
foreign laws.
we gave some examples during, in our principal briefing, but also an oral argument. But a right to, a requirement to arbitrate disputes arises under the Federal Arbitration Act, and that would be unaffected. So if there's a dispute as to something that occurred in the original publishing contract and it requires arbitration, you still got to do that. Limitations on the ability to audit, contractual interpretation, confidentiality obligations, all of those would arise under state law. And actually, prior to the Siegel case, most courts that interpreted this clause had focused in on the state law aspect of it to say that, this doesn't essentially tear up the contract, right? The contract doesn't go away. What happens is you extract the copyright grant from the contract, and you address that separately. So that was another aspect of it. And then foreign laws, right? This is where the rubber meets the road. What is it? What are other foreign laws? We talked about in oral argument, we talked about the potential for that to reference potentially moral rights.
Right.
As you all
Right.
know, any contract that you're signing has a waiver of what? Moral rights.
You know what? Another one is work for hire. So we have work for hire rights here in Germany.
Right,
They
but
don't.
yeah, but moral rights are not waivable under many foreign countries' laws. And in a dispute, I mean, we're going to get back to the question of, is this an issue of ownership or an issue of infringement or a dispute? Because if we were to apply a foreign country's laws in a claim for moral rights, we know that several foreign countries do not allow waiver of those moral rights. But again, I'm still struggling with the distinction between a claim based on a dispute or infringement versus a claim based on ownership. But if I can just, let's talk just practically for a minute here, okay? A judge sitting or a panel of judges sitting in the UK have two plaintiffs in the courtroom, two plaintiffs who have acquired rights to two different songs, one from a British composer, the other from a US composer. Each plaintiff paid $1 million for the rights to the song. And plaintiff one, or plaintiff A, who acquired the rights from a US composer, is now seeking to enforce their rights to this song, despite the composer in the US filing a termination notice. We're asking that judge now to enforce a US law to terminate those rights while recognizing the rights of the plaintiff sitting next to him, whose rights arose under UK law because the composer was based in the UK. I'm just having trouble seeing how this is practically applied
Yeah, but
by
Rami,
courts
the
in
same
foreign
could be said
territories.
for literally every other instance in which U.S. law conflicts with a foreign law. If you have different parties and you're asking a foreign court to look at, you and decide whether or not you've got a choice. I mean, this is choice of laws 101. And I mean, I understand that there are issues that have to, and I'm not, making it out to be overly simplistic. What I've always said is I don't disagree with the premise that there are difficult cases potentially in the future that may arise in a foreign territory. But I have to say, to me, it's a big distraction because what we're talking about here is U.S. litigants, right? U.S. company, everybody involved is in the United States. And everybody was subject to the jurisdiction of the personal jurisdiction of this particular court. And so, from our perspective, this has never been about what foreign courts are going to do. Look, if we ever have to go enforce these rights in a specific country outside of the United States, and Resnik steps in and says, no, 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 I'm the owner over here, and so we'll have to have that fight at that time, right? But right now, we've got folks that are every single person, whether it's the licensee. Let's say we had to bring an infringement action, Rami, against ABC because that's how this all started, was a potential sync license,
Right.
right? They're subject to jurisdiction in the Middle District of Louisiana. I promise that we can get personal jurisdiction over them. All right. The Resnik is subject to personal jurisdiction here. Everybody's under the jurisdiction of this court, and everybody's American. Everybody in that court is what we're talking about is like what happens within the United States. And that's a really important thing about extraterritoriality. Just because something has foreign effects doesn't mean it's a violation of the extraterritoriality principles. Because what you look to is what is the conduct being governed? Every bit of conduct in this case occurred in the United States, right? And so the fact that a ruling in the United States has an effect outside of it can be said for countless legal issues. And so it's easy, I think, to get tripped up on how is this going to be interpreted in a foreign territory, this, that, and the other, and oh, this is chaos. I disagree wholeheartedly.
No, I
These
mean,
issues have to be discussed, or choice of laws provisions have to be, or choice of law issues have to be dealt with in courts every single day. And I just don't see that this is being an outlier from those other cases.
as I mentioned earlier, there's extraterritorial reach for a lot of different kinds of U.S. laws, like securities and financial regulations, Sarbanes-Oxley, antitrust kinds of things, where the countries outside the U.S. don't have similar laws, but they still recognize our laws. That's not an unusual thing. Arbitration, bankruptcy laws here, sanctions like OFAC sanctions that they don't have in other countries, but they will respect those. It's not an uncommon thing at all, as we mentioned earlier. But Rami, to your hypothetical about the US and the UK songs, so one of them is a US copyright and one of them is a UK copyright, right? And so
Yeah.
the issue, so wouldn't that just mean that only the US one would have the termination?
The right to terminate, right.
But they could still, yes, right. So that's the answer, isn't it?
So Tim, believe me, I appreciate the argument that you just asserted, and I'm not entirely disagreeing with you here. I'm just trying to sort through the different sides of this. Just hypothetically, if Resnik were, for whatever reason, a UK entity or a UK national, you think this comes out differently?
So let me show a little bit of humility here and say I don't know.
Okay.
I don't know, and I think that's one of the things that we've always tried to approach this in a way that had a little bit of humility to it, understanding that we're the ones that are bucking 50 something years of industry practice. And so coming in, table pounding, saying, all of you are idiots and this should have never been done. That's just never been something that I was interested in doing. What I was interested in doing is saying, I think there's a different way to look at this, particularly post Kurtzeng. And Kurtzeng really did provide the jumping ground for this by adjudicating what it means to arise, or rights that arise under this title. And so post Kurtzeng, I felt strongly, I felt this way a long time, that there was another way to look at this and that potentially we were misreading this statute. And that's the way that I've approached it. And I don't have every answer to those hard questions that you're raising. If that comes about, right? If I have a case, you can be damn sure that I'm gonna come up with an answer.
But
right?
I'll give you an answer right now. I'm going to bang my fist on the table here.
All right.
Corcovado. I mean, that was a case in Brazil. Everything was Brazilian about that case. It was about Antonio Carlos Jobim bossa nova songs. It was the parties. Were from Brazil. It was written in Portuguese. It had a choice of law clause in Brazil. Everything was about Brazil, and yet they were able to come to the U.S. and to enforce it under U.S. to get the benefit of the U.S. law with respect to termination because it was considered an asset.
Well, but to Rami's point, that's a different hypothetical, because what Rami's saying is that This is a U.S. asset owned by a UK, that was transferred to a UK publisher. And that in the Corcovado case, it was everything was Brazilian,
Okay, but I
as
thought
you
his
point out,
question
right?
was, what if it was a UK? What if
Well,
Resnick was
I
from the
think it
UK?
comes out. I think if I, and maybe I misunderstood Rami's question. It- Look,
No, no, you
even
understood me.
if it were
Yeah.
even if let's say that it was a UK publisher, right? I don't think there's any doubt in the world that the court, like in Corcovado, would have recognized Vetter's right to terminate that that transfer, right, or terminate the copyright grant within the United States. I think Rami's question is, well, if it was, uh, uh, if it was to a UK publisher, would the result be different? And let me say that under my reading of the Fifth Circuit's opinion, I'll wager. All right, you got me. I'll take the bait because the copyright arose under it doesn't matter who you assigned it to, right? Or what the governing law is, because the right arose in double shot under the United States Copyright Act. My reading is even in that situation, regardless of who you assigned it to, the grant would still be terminable. And then you ask, well, what gets terminated? And it would be the rights that arose under the Copyright Act. And in this case, that would be the right to exploit the work throughout the world. So I'll wager a bet on that one that it
Okay.
doesn't come out different. You got me.
All right. So Rami and Tim, let's kind of wrap it up here. Are there,
Sure.
because there's so much here and we could spend hours and hours on this, and we've barely scratched the surface, I feel like, but we've done a lot. I think we got to the core of it in terms of the language here and in terms of the other cases. These were the questions that the judge, or the issues that the judge raised here, and the territorial, the treaties and extraterritorial.
Let me just, Bill, if I can, just Tim, I want to acknowledge, and obviously I am playing devil's advocate a little bit here to challenge you on a couple of your points, but I do want to acknowledge the theory of national treatment also applies uh, in the inverse, and that is, for example, in China, the term of copyright is life of author plus 50 years. A Chinese national seeking to enforce their copyrights in the U.S. saying, well, no, I want the benefit, and we're going now back to the ownership versus infringement distinction, which I'm still struggling with, but seeking to enforce their ownership rights for a period of life of author plus 70 years, which is the law in the US, would not get the benefit of that because the Berne Convention does not allow for, the Berne Convention has a provision that limits it to the lesser of or the shorter of when you have competing copyright terms. So that is consistent with what you've asserted and what the Fifth Circuit held in this case, Tim. I just want to acknowledge that that is part of the national treatment analysis.
Yeah.
That's great. And any other thoughts or issues that you guys want to hit on before we wrap this up? And maybe we'll have you on again. I mean, that would be great.
Yeah, I mean, look, this is complicated stuff, and Lord, if there are civilians that are listening to this podcast, God bless them. They have probably we've utterly confused them. I hope it's lawyers, but look, I think we're really happy with the way that things came out. Um, we're not, like I said, we're not spiking the football here. I mean, this is not the time for that. This is the time to continue to work um, towards a more artist friendly and a more author friendly world. At the end of the day, we're not anti industry in any regard. We recognize the importance of our publisher friends and our label friends and the success of our artist clients and our songwriter clients. But for us, this is about fairness. And after you've had your turn with my client's copyright, when it's time to give it back, don't slice it up into 181 pieces and then tell me I only get one slice.
That's
That's
great.
not fair.
And the issue, you have people investing a lot of money in their companies or their private equity buying catalogs or whatever, and they have an interest in keeping the copyright as long as they can. And at the same time, and then you have the creatives who want to get their copyrights back. The other issue, and we touched on this when I was talking with you before this taping, is this is a new, different world, right? It's not like it's unusual to get reversions of copyrights contractually. Okay. In fact, Chris Castle wrote a very fine amicus brief where it's the only amicus brief that was quoted in this opinion here, where he said it's not unusual to have reversions. So it's not going to be the end of the world if the reversions are worldwide by law, because contractually it's pretty normal to have reversions of copyright in a deal. It might be 10 years, 15 years, 20, 35. Here we're talking about 35 years under Section 203. But is it a new world now where it's like in the old days when these works from the 60s and 70s and 80s were around? I mean, contracts were pretty egregious in the sense that they were forever, and they still are, a lot of them. But Tim, can you address that? And you're also, your firm does handle transactional work as well in the music industry.
Oh, listen, we're primarily a transactional firm. My law partner and I pride ourselves on the transactional work that we do. I'm a former litigator. I hung up my litigator hat a long time ago. This was, I can be very selective in the litigation cases that I take, and this was obviously one I wasn't going to pass up. But to your point, yeah, we are moving in that direction. We are moving more in an author-friendly and an artist-friendly direction where we can get contractual reversions in deals that, I mean, this would have been unheard of 10 years ago. But there's so much more leverage with the rise of administration-only deals where ownership is not being, transferred, but simply it's an exclusive license. We're just looking at a whole different landscape than we were in the 1960s. And we think that this is a part of a larger trend towards a more artist-friendly, industry. And who's not in favor of that? I mean, I know who's not in favor of, but if we all owe our careers, every single one of us owes our careers to the people that are creating. And without, keeping them at front of mind, I think we start to make some questionable calls. And withholding the right to exploit the work internationally post termination, I think is one of those questionable calls. Asserting work for hire clauses as a grounds to strip recording artists from their termination rights, I think is a very questionable call that we're going to have to address at some point. But yeah, this is a part of a broader trend, and we welcome it as transactional attorneys, and we hope it's embraced by everyone. But clearly we're excited with the decision, and I thank you for having me on to talk about it a little bit.
Congratulations. And Rami, anything else to add at this point?
No, it's been a pleasure. Thank you for having me on the podcast.